Good afternoon. We'll get started in just 1 second. Okay. So good afternoon, everyone. My name is Mano Sumahoro. I'm an associate at Jackson Walker, and I'd like to welcome you to the CLE, Estate Planning 101, How Wills, Trust, and Probate Fit Together. We're gathered here today because at some point, nearly every attorney will get a call from a grieving client who needs answers fast. And estate planning is one area where getting it wrong can have lasting consequences. So to help us avoid that, we've assembled a fantastic panel who will walk us through 5 essential questions you'll need to answer when the call comes. Specifically, what happens legally when someone dies? How is real property handled in probate? What happens to your business interest when the owner dies? How are some personal injury claims addressed in probate? And what are some of the most common pitfalls in estate administration? And how do you avoid them? But let us dive in first by introducing our panel. First, we have Michael Mahoney. Michael Mahoney is a Texas licensed attorney focusing on probate, estate planning, and guardianship law. He assists individuals and families with navigating probate, including contested probate and dependent administration, creating tailored estate plans and handling guardianship matters efficiently and clearly. He has represented clients in over 40 probate courts across Texas. He is a member of the Dallas Bar and DAYL, while he serves as chair of the Solo and Small Firm Committee. He's also a member of the St. Thomas More Society. Michael earned his bachelor's degree in international business from the Franciscan University of Steubenville and his JD from the Ave Maria School of Law, where he served in the student body and was named on the dean's list. Outside of his practice, Michael is a husband and father of 4 who enjoys running, biking, and playing tennis. Next, we have Chris Omar. Chris previously served as a judge of Dallas County Probate Court Number 2 from 2011 to 2014. Since leaving the bench, he has built a probate litigation practice that handles contested and uncontested matters across North Texas. A proud graduate of SMU, Mr. Wilmot is an equity partner at Farrow, Gillespie, Heath, and Wilmot LLP, a majority women-owned law firm that also provides services in the fields of estate planning, commercial real estate, business litigation, corporate governance, and employment law. Last, but certainly not least, we have the Honorable Judge Margaret Jones Johnson. Judge Joan Johnson is served as the presiding judge of Dallas County Probate Court Number 3, a statutory probate court from 2015 to the present day. She previously served as the local administrative judge of Dallas County's 3 statutory probate court. In her role as presiding judge, she has conducted over 13,000 hearings, numerous bench and jury trials involving probate, guardianship, trust law, and mental illness. She's monitored numerous guardianship cases and overseen the administration of estates worth over $5 billion. As judge of Dallas County's only mental health court, she presides over 1,000 cases involving orders of protected custody, apprehension of persons with or without warrant, emergency detention, and involuntary commitment. She's a proud graduate of the University of Arkansas at Little Rock and holds a JD from Texas A&M. Now that we know our panelists, our first order of business is to understand what happens legally when someone dies. And Mike, I'll turn that question to you. What are some most important things that attorneys should understand about probate when a client's loved one passes away?
Yeah, thanks, Mano. The probate is a tool to help manage the assets, debts, and claims that belong to a decedent's estate. When somebody passes away, their person passes away, but their estate remains. And so knowing when and what a probate asset is and what a non-probate asset is critical for practitioners who come into contact with a situation where somebody passes away.
Okay, and related to that, how would you distinguish between the person and the estate when someone dies, and why does this matter?
So a person and estate comes about when you're born. Everybody's born with a person and an estate. Your person is your body, and your estate is the things that come along with your body. When you're born, you have nothing in your estate. As you grow older, your estate accumulates, assets and debts and claims, potentially, a car, a house, and your person is there to manage your rights, including the right to own property. When you pass away, your person passes away, and that's the person who has the ability to manage your estate. And so at this point, there's nobody who has the rights and powers to manage your estate. What probate does is it takes the rights of that person and invests them into a fiduciary, an administrator, or if there isn't a need for an administration, it allows for the transfer of property out of that person's estate to the rightful heirs or beneficiaries.
That's a fair point. Chris, how would you explain the difference between probate and non-probate assets to your clients, and what common misconceptions do you often encounter?
Well, first off, I'd say that we're pretty clever in probate law. We come up with some really complex terms sometimes, but this is not one of them. And this is like it is either a probate asset, which goes through the probate process, or it's a non-probate asset that is something that passes outside of the probate process. And so, what are some examples of probate or non-probate assets? That's what I like to start with first. These are things um, that that pass without you ever having to go to court. So the primary example of that would be financial accounts. If you are married to somebody, or maybe you're not married, you just have an account that has a joint tenant with right of survivorship designation on it, then the survivor of those two people or three people or however many are on there is the person who owns the property after the first one dies. Sometimes you got a financial account that just has what they call a pay on death beneficiary. And if these are individuals, then basically what you tell your clients is, well, they can go over there, they show the death certificate, and the bank's going to let them have their share of that money. If it doesn't have a beneficiary designated, or the person who was designated predeceased, or there's just a defective designation, then it would default to going to the probate estate, and that means that that asset would be a probate asset. Some other things that are non-probate assets, life insurance. If you have a life insurance policy payable to somebody, then that person receives that outside of probate. You have something called a transfer on death deed, sometimes called in other contexts a ladybird deed. That's where, like a house, you have a deed that says, this, I'm going to retain a life estate in this house, but when I die, it passes to so and so. And so that house would pass outside of probate. The title would vest in the grantee immediately upon the death of the grantor. There's a similar thing, interesting enough, that you can do with your car title. If you ever go look at your car title, you can see on the front part of that you can basically designate who gets your car when you die. So if you ever get a car title, if you ever finish paying it and you get the car title, look at that and consider going ahead and saying that the title to this car passes to so and so if I were to die. Another thing that might be outside of probate or assets that are held in trust. But if other than that, everything else pretty much is something that passes through probate and probate administration. They're called probate assets. And these are the properties that are subject to paying the estates of administration and which pay the debts of the estate before they can be passed on to the beneficiaries or the heirs. Generally speaking, and we'll come back to this later, but generally speaking, these non-probate assets are not subject to the claims of creditors and estates expenses of administration.
Okay, that's good information. And how do you help your clients understand their potential personal liability when they serve as an executor or administrator of an estate? Chris?
Okay, that's a kind of a complicated question, but I think the first thing I would want people to know is that you are not responsible for other people's debts. If your mom and dad die, you're not responsible personally for their debts. That's what their estate is for, to pay those debts. And if there's not enough money in the estate, then maybe those debts just don't get paid. Nothing passes down to you, but you don't have to come out of pocket to pay the debts of an estate from a legal perspective. Okay. But there are a lot of times where you are going to be paying out of pocket. Say, if mom or dad did not get a prepaid funeral set up, haven't got that all arranged, you're going to end up paying out of pocket to pay for the funeral, and that can get pricey. That's ultimately reimbursable from the estate, but that's something that you may end up having to pay out of pocket. There are certain expenses of administration that you end up paying out of pocket. You go and hire a lawyer to probate a will or open an heirship and independent administration. Typically, you're paying out of pocket up front to pay that lawyer to go and do that. Again, once you get access to the estate property, you can reimburse yourself, but you may end up having to deal with that. Another place where you may end up having to pay out of pocket, at least up front, is if you own, and we'll come back to this in a little while, but if your decedent had real property that's subject to a mortgage, or a home equity loan or a reverse mortgage or something like that, that the bank is going to want their money. And if you don't have access to money to pay that from the estate, you might be well advised to go ahead and keep paying that, or to pay property taxes as well, or pay for insurance on the house so that you can protect that asset up until the point of time that you do have access in the estate. Generally, your personal representative, the executor, the administrator, they're not personally liable for the decedent's debts, as I said. A big exception is if you're the surviving spouse. Okay. If the surviving spouse is the executor, debts get paid first and foremost from the decedent's separate property, but the entire community estate is subject to the claims of creditors, including the expenses of administration. There's a little bit of I guess, a misunderstanding about how this works. They think, oh, well, it's just, the decedent's half of the community estate. That's not right. It's the entire community estate. And so that's a situation where somebody, if they're the personal representative, could be personally liable for debts. That's if you're the surviving spouse. Then one other thing, I'll stop, is that sometimes you got that property through the non-probate process. If there's not enough money in the probate estate to pay debts, sometimes creditors can come in and try and get access to the non-probate property to make sure that their claims are satisfied. That's a court process, and then they do have to go to the court and get an order to do that. Last and not least, a personal representative can end up having to pay things out of pocket if they wrongfully reject a claim. There's a claim process in probate. It's very similar to bankruptcy, if you're familiar with that. But people come in, they say, "Hey, you owe me money," and if the personal representative rejects that claim improperly, the personal representative can end up personally responsible for paying the claimant's attorney's fees. And so, I hope that answers the question.
No, you did. Thank you so much. And from the bench, Judge, what are some of the biggest mistakes you see attorneys make in probate matters, and what should you wish more practitioners understood?
Not following the local rules,
Mm.
just basic little things that could cost them their client a lot of money, like conferencing before you go to a hearing to try to resolve some issues. Communicating with their client about the obligations that they have as a fiduciary. And as Judge Wilman was saying, when you take on this responsibility and other members don't trust you to do the right thing, then they can have you requirement of a bond. So it's very important that the client or applicant understands that this is a very big responsibility and that you can be liable if you don't do the right thing, such as I guess the best way to explain it is if it's a dependent administration, you have to play the game. Mother, may I go down the hall? Mother, may I sell the car? You have to have permission of the court. And if you act without authority, then that's where you get into trouble, the court and the other beneficiaries.
No, that's a valid point. And something people are often concerned about is what happens to their real property when they pass away. How is that handled in probate? And Chris, I'll turn to you for this one. What happens with house and probate, and what are some critical considerations that practitioners must address?
Well, this kind of turns on whether or not you have a surviving spouse or not. Okay, let's assume that we have a surviving spouse. One of the most important things that you need to let your clients know is that if you have a surviving spouse and the decedent has children that are not also children of that surviving spouse, unless there's a will saying that the spouse gets the house, in an intestacy, the decedent's interest in that property will pass directly to the decedent's children. You have a co-ownership situation. And what's important to know, however, is that the Texas Constitution and the Estates Code protect the surviving spouse against a partition. As everybody knows, if you co-own property, well, as lawyers should know who passed the bar, if you have co-own property, you have a pretty much, a clear right of partition. You say, hey, look, I don't want to own this property with you anymore. If you're not going to agree to sell it, I'll go to court and we'll get it partitioned. You don't get to do that with a surviving spouse. So your stepmom is living in the house and you own half of that house. Well, she has a Texas constitutional right to stay in that house for the rest of her life. It's what we call a probate homestead. And you can't partition. And there's allocation of responsibilities there, but that's kind of getting into the weeds. But that's something really important for people to know and understand. You can't throw your stepmom out, and so they get to stay there. And one of the things you can't force her to sell. You can't force her to buy you out. You are in a situation where you are co-owners, and you just have to kind of wait it out. Now, if you get along well with your stepmother, then maybe that's not a big deal. But usually the things that come across my desk is that there's discord. So that's the first thing that you need to know about how real property is handled in probate. Just as a practical matter, you're going to get called and people, who you're the only lawyer they know. And so what do I do? Well, here's some practical things that you should tell them to do. If you don't have a surviving spouse in the house, then you need to secure that property. You might need to, get new locks. You might need to secure the windows, make sure the gates are locked. I mean, that's very practical. You want to go through and you want to remove important papers, collect them, put them in someplace safe so that somebody can't just break in and rifle through and take those. We're talking about bank records, life insurance policy, deeds, titles to cars, things like that. You go in, find that, and collect that and keep that safe. You want to remove the valuables. You want to remove any firearms, just so that if somebody walks in there or somebody decides they want to go in and help themselves to the decedent's property, they're not going to find anything more than maybe clothes. Okay, so tell them that they have a right to go and do that. If they especially if they're all on the same side. If you've got people who are, adverse, then that may not be the proper thing. You need to get an agreement, but ideally you need to try and secure that so that people can't break in and take the valuable stuff. Things that you'll want to do. You want to make sure you turn off unnecessary utilities, but make arrangements to pay for others. That's a situation where you may end up having to pay out of pocket. Maybe mom and dad's bank account has an auto draft. Okay, well, maybe you don't tell the bank that they're dead yet, so that the bank will still pay those bills for you. You want to stop the newspaper. You want to, maybe if they've got a pool, you got to make sure that somebody's taking care of the pool. You want to make sure the yard's getting cut. You don't want to get some sort of notice from the city that the yard's, grown out of control. So another thing you want to do, you want to collect the mail. Once you get it appointed as the administrator, you want to forward the mail. And lastly, maintain property insurance on that property, because if it lapses and it's vacant, it's very, very hard to get an insurance company to provide property insurance in that situation. And again, back to property taxes, you will probably want to make sure that the property taxes get paid if they're not getting paid through the escrow and the mortgage, which we'll talk about probably in a little bit. But you don't want to end up in a situation where you get a notice of a lawsuit from the county saying you didn't pay property taxes and you owe all this money. And you're like, wait a second, I'm not even the personal representative. So,
Yeah, that's a fair point. And on the topic of securing property after someone dies, how does your analysis changes, if at all, when the property is owned outright versus when it's subject to a mortgage?
so you do have to consider, the mortgage has a different player in the game, right? You have a bank, a lender who wants to get paid. They don't really, but the good thing is most of the time they really don't care whose ox is getting gored here. As long as they're getting paid, they're not gonna come in and, demand that you open an administration. They're not gonna come in and demand that you, to try and foreclose because you had an event of default. They want to get their money. So if you can, keep paying the mortgage. If you can, bring it current. Use that non-probate money to do that. You can do that. There's nothing wrong with that. That's just smart. If you do have to go, and sometimes if there's, that's the only thing that's going on, you can go through a non-probate process called an affidavit of heirship, where the heirs get together and say, these are the people who own the property. And then you just get together, you sell the property, and you pay the mortgage at that time. Okay, you can do it that way. If you have to go through probate because you have a will or because you have other things you have to handle, you'll get a personal representative will be appointed, and they're going to have to give notice to secured creditors, and that includes the mortgage holder, whether it's a purchase money mortgage or a home equity loan or a reverse mortgage. You got to give notice to the creditors. And the personal representative should go through the deed records and see if there's any other lien holders out there. That's something that, sometimes people forget is, oh, well, maybe there's somebody with a higher priority. Maybe there's a mechanic's lien out there. So you got to worry about that. Sometimes there's a judgment. And again, just be aware that there may be a mortgage out there. And if you ignore it, that's still going to come due. They're going to have penalties. There's going to be extra interest. They're probably going to accelerate, and they can come in and foreclose. So, if there's a mortgage, you want to pay attention to that. One thing that people don't always think about is that maybe mom and dad went and got a reverse mortgage before they died. And that kind of sucks. Pardon my language, but it's not fun because you think that, oh, wait, mom's got this $700,000 house. I'm going to sell that and we're going to split the money and I'm going to send the kids to college. Well, if mom went out and got an equity, got a reverse mortgage on that and cashed it out, well, that's going to have to get paid before you can collect any of the proceeds. So, yeah, I hope that answers your question.
You did so much so. I'm gonna have to talk to my mom after this call. So,
Oh, one last thing. If you're in
Yeah.
a court supervised administration, so it's, again, with these very creative probate words, we have an independent administration, which is if you are independent of court supervision. We couldn't come up with a better word than dependent administration to be the opposite of that, and that just means court supervised administration. If you're in a court supervised administration, if you're going to sell property, sell real property, mortgaged or not, there is a process you have to go through. You got to give notice. You got to go get a court order. You have a hearing to prove it up. So it's kind of involved. This is one of the reasons that Mr. Mahoney and other estate planning attorneys will tell you get a will so you can be independent.
Okay, well, Mr. Mahoney, I'll bring you right back in. How does homestead status impact the administration of an estate?
Yeah, so building off of what Mr. Wilmoth was saying regarding the spouse being protected and having that constitutional right, homestead is a constitutional right given to the spouse, minor children, and adult incapacitated children of the decedent. And it can set aside the homestead for their use, and additionally, it can really while the surviving spouse is surviving or the minor kids are there, they have use of that property even if it's co-owned by somebody else, like the kids from outside of the marriage. But also too, it has a way of passing outside of any community debt as well. So if there's a surviving spouse or and they have community debt, such as credit card debt or some other sort of debt, as long as there's a minor child of the decedent, it doesn't matter if the minor child's living in the house or a surviving spouse, that house can pass to the heirs, even if there's an adult child. It passes to the heirs free of that community debt. That's not including any sort of constitutionally protected debt, such as a purchase money loan, taxes, anything else protected by the Constitution. But generally speaking, a homestead allows for debt for property to pass for outside of the community property debt.
That makes sense. And then, Judge, what are some common issues you see in your court involving real property, and how do you recommend avoid? What can attorneys do to avoid unnecessary delays or complications?
Know that there may be a homeowners association. They they kill me. They come in and they try to take over, and they don't believe that these people have rights. It's like the homestead and so forth. So I would be that would be a main thing that I would check.
Okay.
Also, when you have a former spouse, children by that former spouse, and they die, also know that the new spouse, the kids, they don't want to get along. Okay. And in my opinion, if there's children that they have in common, makes it a lot smoother administration. But when they don't, I have to bring them into the courtroom and give them the come to Jesus talk. You're gonna, and even those that are blood related, I still have to have that talk. There's only one pie. How big it is upon division is going to be determined by how well you guys get along. That's the bottom line. That's the best way to explain it to the litigants. And also, we're talking about property, but there are a lot of kids, and I've had a few cases where these kids have invented something. Intellectual property, that is a property right as well. And so some of the parents don't know how to deal with that. They're coming asking for their passwords and so forth. And the intellectual property covers patents, trademarks, and copyrights. And a lot of kids are doing beats and all of this stuff. I would advise those attorneys that do a case involving a minor or an adult with property rights, make sure that they engage an intellectual property attorney, because if they don't, that's considered malpractice. And they need to understand that they have to go through certain ropes and loops in hallways that they wouldn't have ever imagined. And so they just need to make sure that they engage someone that can help them navigate that.
That's a fair point. And so ideally, it's smooth sailing after death, but oftentimes there are litigation matters that are still open, or there are personal injury claims that have to be addressed. Mike, I want to ask you, what is the difference between survival claims and wrongful death claims? And then how does that impact the administration of the estate?
So I could probably take up the rest of the time talking about this. I do this a lot, and I find it extremely fascinating, but I'll keep it short. So wrongful death and survival claims are governed by the Civil Practice Remedies Code, Chapter 71, and they're distinct, different causes of action. So a wrongful death claim is a claim that is brought from the actual damage caused by the death of the individual. And that claim is only owned by the spouse of the individual who passed away, their kids, or their parents. That claim passes outside of the decedent's estate. Decedent's estate creditors are not able to go after that money. It is completely separate from the decedent's estate. It is the pain and suffering that the mother and father have of losing their kid, or the spouse or their kids. So a survival claim, on the other hand, that is a claim that the decedent had prior to death, whether they died in an accident that caused the injury that they had. So if they had some pain and suffering moments before they passed away, or they got into a car crash, or another claim for personal injury that happened months before, and then they died from unrelated causes like a heart attack. That claim is a claim that is owned by the decedent's estate. And that claim can only be brought by an administrator or an executor of the decedent's estate. Only an administrator can sue or be sued on behalf of an estate. An estate can't be sued, the heirs can't be sued, and they can't sue until they ask the court for permission to sue on behalf of the estate to bring those claims.
Okay, so that makes sense. And then Chris, my question to you would be, before we engage a personal injury attorney, what should administrators or guardians of the estate understand about how those contracts are treated under probate court?
So what often happens is people show up and talk to the personal injury lawyer before they've been appointed as the administrator, right? So they go in, their loved one was killed in an accident or something horrible happened, and they go in and talk to the personal injury lawyer. Personal injury lawyers need to know and understand what Mr. Mahoney was just saying, is that, you can't, while the wrongful death claims belong to the individuals, the survival claim belongs to the estate, and you need to go through a probate process, particularly if there is a substantial survival claim. What they need to know and understand is that the attorney fee contract that they sign with the personal injury lawyer has to be approved by the court if it's for a fee that exceeds 25% on a contingency basis. Okay. And that you can't even, if you read the law strictly, you can't even sign that contract until you get permission from the court. So you're in a situation, that's where you got to go to the court, get an administrator appointed. Oftentimes, if you've got a nuclear family and you can get an independent administration pretty quickly, that's a good way to go. If you are in a rush, you need to get an administrator appointed quickly. Maybe you just do a court supervised or dependent administration. And then one of the first things you do is you have an application for approval of the attorney fee contract. Okay, and you need that order. The other thing that you need to know is whether it's a court supervised, the personal injury case doesn't necessarily have to take place in the probate court. You go somewhere that has proper venue and jurisdiction for that. It can be brought over or brought in the probate court, but usually, you bring these cases in courts that do personal injury cases all the time, and that's probably best for your client and best for your lawyers, because that's where they are used to doing their job. But oftentimes you will reach a settlement. You've got some insurance money that's available, or you were required to go to mediation. You're going to settle it. Well, before you can finally and firmly settle and fund that settlement, if you're in a dependent court supervised administration, you need to go and ask the court to approve that settlement, because your administrator they have authority to compromise claims with court approval. So you got to go in and you got to explain to the judge why this is good. One of the things you got to look at when you're dealing with that is how much of the settlement is being allocated to the survival claim and how much of the money is being allocated to the wrongful death claim. The temptation, especially for the plaintiff's lawyers, is to allocate everything to the wrongful death side. Okay, and why? Because as Mike was saying, those the wrongful death claims aren't subject to the claims of the creditors. Whereas the survival claims are. And if you've got an administrator who needs to get paid, you've got other assets, expenses of administration that need to get paid. If you've got debts, then there needs to be, if there is a viable, valuable survival claim, courts are going to look a little bit kind of sideways if everything's being shifted over to the wrongful death side. So just be mindful of that. I think I see Judge Johnson kind of nodding her head occasionally on that.
Mhm.
One other, and you're welcome to jump in anytime on that, Judge, because you're on the other side of the bench on that much more often than I am anymore. One other thing I would alert people to is what I call the affidavit in lieu trap. Okay, getting a little into the weeds. Probably from taking the bar that you in an administration of an estate, you have to create an inventory. Okay. You can list the claim for the survival action as a claim of the estate in the inventory. But there is, in the normal process, the default process is that you identify all the assets of the estate and you file an inventory with the court within 90 days. The court looks it over. They say the form looks good to me, and you move on. There's an alternative that's out there that what we call an affidavit in lieu of inventory. The idea of this was kind of a privacy-driven thing, so that you have a little old lady who's got millions of dollars, and you don't want to put an inventory out there that says, "Hey, little old lady over on North Haven has millions of dollars and lots of valuable art." And so what the legislature created about 10, 12 years ago is a process where you create an inventory, you give it to the people who are entitled to the inventory, but you file an affidavit with the court saying that, look, there are no unpaid debts of this estate that are not secured by real property or expenses of administration, and a copy of a verified full complete inventory has been given to all the persons who are entitled to that. So we're not going to file it, and so you file that affidavit in lieu. Well, there's that first part of there are no unsecured debts of the estate is one thing that you're affirming in that. Well, if you got a personal injury suit, you got a survival claim, most likely you got medical bills. Those are expenses, and you want those to be covered as part of the settlement proceeds, or at least a judgment if you're going to judgment. And so you don't want to put yourself in a position where you have under oath sworn that there are no unpaid debts. And so that would put your personal injury lawyer will lose his mind if he realizes that you've somehow waived that, and somehow that's going to get eaten. We're not going to be able to recover that, but somehow they're still going to have to get paid. So that's what I call the affidavit in lieu trap. So just be mindful of that when you have a pending personal injury survival claim in probate.
Okay, well, that makes sense. And Mike, I have one more question for you in this section before we ask the judge to help us understand what happens to your business interest after you die. So Mike, what are the priority of debt consideration when an estate is both collecting and potentially owing debt?
Yeah, so the probate process, we have to have money go to the heirs. There's money that goes to the creditors. So how does it all come into place? How I like to think of it is there's a funnel. And in the funnel, there's a bunch of holes in it. And on the side, the holes are each creditors. And there's 8 holes. There's 8 levels of creditors. And you take the assets of the estate and you put it in the top of the funnel, and it slowly goes down. At the very bottom, it's the heirs. Money will go out of these holes according to the creditors, and it comes out in a certain order. At the top of that, the number one priority claim is the expenses of the last illness and funeral expenses, capped at $15,000 each. And then the next claim is going to be cost of administration of the estate, and so on and so forth, all the way down to class 8 claims, which is going to be unsecured creditor claims. There's ways of dealing with those claims and the debts in the probate administration, very similar to what Mr. Wilmuth was saying regarding bankruptcy. There needs to be notice given to them. Certain debts need to be brought, those claims need to be brought in the probate court and approved by the judge before they get paid in the order of administration. But then ultimately, at the very end of that process, the heirs are paid with whatever is left after the debts are discharged or paid in the administration. So it's looking at the debts and knowing what debts of the estate are and what the rights of those creditors are is really important when you're in an administration and you are looking at what assets there are versus the debts and what's going to be the ultimate number that the heirs are going to get.
That's helpful. And just as a reminder to our chat, if you have any questions, please feel free to put them in the Q&A function. We'll try to answer those at the end. Judge, earlier you alluded to businesses when people die and considerations to bear in mind. So could you tell us a bit more about what happens to decedent's business interests when they die? And especially in this world where we're not navigating with AI, how does that impact your response?
Okay, well, I find that if it's not a family-owned business, a lot of times no one knows how that business is run other than the owner of the business. And businesses can be in a good relationship or a bad relationship if there are partnerships. And you got to look at the type of business associations that are out there, which define responsibilities and liabilities of each business association. So you've got to look at that. And if you're not familiar with that, you may want to get co-counsel engaged so that you won't commit malpractice. If you are not quite sure how to navigate that, even with the co-counsel, sometimes the judge will appoint someone to help run those businesses and make sure that taxes are paid, employees are paid, and to make sure that if it is an asset of the estate, if they're under will, beneficiaries under the will, or the heirs, no will, want to continue to have ownership of that business? Or do they want to buy the ones that don't want to be owners of it out? Valuation of the business. And it may be some type of business that you have to get some type of approval from the federal government for like intellectual property or trade secrets or something. You want to make sure everything's protected, and if the family still wants to keep that. Some people use what do they call those people? They're in a fiduciary capacity, but they're not really administrators over that. What starts with an R?
Receiver?
Thank you. It was on the tip of my tongue, but I couldn't remember. Okay, so some people appoint receivers to protect money, and it could be someone out in the community that would be qualified to do that and meet the statutory requirements and criteria. I just don't feel comfortable with that, and I always like to have an attorney who wants to have that type of responsibility and know what they're doing, because you don't know these people out in the community. It's hard enough trying to make sure that the administrators are doing their part and they have some type of coverage, liability coverage, you know what I mean? So that's what you're really looking for when you're doing administration, including a business. Some people have more than one business. Okay. So just keep in mind that, hopefully they're not in the process of filing bankruptcy and all of that, because the administrator will have to go over there to bankruptcy court and deal with that as well. So just know that it involves a whole lot of stuff. I can say probate to me as a as a daughter of a former bankruptcy attorney, probate to me is like bankruptcy on a deathbed. It's like, you somebody dies and everything is like handled like in the bankruptcy court. It's, you have a lot of power in the probate court to grab cases and all of that stuff. So yeah, I that's the best way to describe it, and that would include, a successful business or unsuccessful business, closing down a business, selling a business, all of that, dealing with employees, employment agreements, honoring those, harassment claims, those come through. So you just everything that could happen while the person was alive, that still goes on, because it doesn't stop because they are no longer here with us. Um, it goes all across the spectrum, from race car drivers to professional athletes and entertainers who have royalties coming in. You still have to have someone to manage that, even though it's just an individual no longer here, but their estate is entitled to royalties. And sometimes that goes on and on and on and on. So it could be a quite daunting experience if you if you don't have it.
Okay.
It can be
Well,
daunting. Sometimes I just want to go,
well, hopefully we do our paperwork right so we don't enter a daunting experience. And one thing I've come across as a corporate attorney is oftentimes when business owners start their business, sometimes because it's just more efficient, they'll list themselves as every officer of the entity. So they're the president, the secretary, the treasurer. I mean, if they can be the spiritual guide, they're also that. So, so to that point, I guess, Chris, my question to you is, what challenges arise when a business owner holds all the corporate positions in an entity and that person dies? And as the judge mentioned, the business has to continue functioning.
Yeah, it depends on the size of the business. I mean, if it's just a sole proprietorship, then usually those things wither on the vine. Although I have seen circumstances where you had a sole proprietorship, but it was a very active, busy business. And so you had to go to the court to get a temporary administrator in place. But let me first say, I'm not an estate planner. I have a partner who is partners who are estate planners who do a really good job at that, but I'm not. I'm the administration side, litigation side. So I kind of see. I'm the one who's called upon to kind of help fix things when somebody didn't plan accordingly. So from a planning perspective, I mean, I think that the observation that's oftentimes you've got an entrepreneur who is just the go-getter, and they want a corporate form, and so that they elect themselves, they're the sole shareholder, and they appoint all the officers, and and then when they die, there's nobody to elect a new officer, right? Until you get somebody who's authorized to vote their shares. So that's one reason that you would probably advise your client from a corporate perspective to maybe you have a shareholder, a minority shareholder who can sit there and have the authority to elect new officers when you die. Same way with the general part. If you've got a limited partnership, who's going to run the GP, the general partnership, general partner, when the visionary who's running the thing dies. You can add things to your LLC agreement that will allow you to do that and tell exactly how you want that election to take place or that nomination to take place. But think about that, because if you've got one of the big things that happens is, well, what happens to that minority interest or that LLC interest when maybe the minority interest holder dies? I mean, that can be a problem too, and that can lead to a lot of litigation if you don't have very clear, here's what happens to that property interest when you die. I had a case in Judge Johnson's court that dragged on for years because there was conflicting information in the LLC agreement about what happened to the minority, to Mama's interest in the limited partnership when Mama died. So I mean, ideally, it's really hard to advise these entrepreneurial clients who are just really good at what they do to let anybody else help. But I mean, it's really important that you say, well, who's gonna run this show if you get hit by a bus? Either in a guardianship or die. Who's gonna run the show then? What you want to, so some ways that you can do that is if you're not a sole proprietorship, you get other people who are authorized to make payroll. You have somebody who can sign the checks, somebody who can pay the bills to keep the lights on, to keep the vendors paid so that you can keep things going until you can get a more rational system in place of who owns it. Sometimes if you haven't planned and there's only one person running the show, you have to go to court and get what's called a temporary administrator. Now, in an ideal world that the probate code and now the estates code set up, you go in, you filed a probate, a will, and you should in about 2 weeks, 3 weeks, you can get your will probated. In some counties, you can actually do that still. In counties like Dallas and Tarrant and Collin and Denton, where you've just got such a high volume of cases, it's not often that you can, show up the first Monday after the expiration of 10 days and get your will probated. So sometimes what you have to do is get a temporary administrator in place. And those kind of jump to the top of the line. Those are emergency kind of situations. And the judges will sit there and say, oh, all right, what are we going to do? But the thing about a temporary administrator is they only have the powers that are listed in a court order granting them powers. It's not like all the powers of a probate administrator. No, you have to specifically say what they can do. And that can be really detailed. And it's very specific to particular businesses. But you can get in and do it. I had this case in in one of the probate courts several years ago. You had an entrepreneur who had a business. He had a flower company. And, fortunately, his son also had a flower company, knew how to run it, came in, got authority to keep paying vendors and to get to the bank account so he can keep that business alive long enough to sell it so that his children could get something out of it. So those are some of the things to think about. I mean, it's hard as a planner to get them, or even as a corporate, the person who gives advice about fiduciary duties and stuff. It's hard to get people to focus on what happens if you die. How does this keep going? But it's super important because if you've got a plan in place of what happens when I die, you can have a board meeting, the next day, electing new officers and running things, as opposed to, oh, I got to go out and hire Chris Wilmoth or some law firm and pay them thousands of dollars to go in and hopefully get the court to approve it. And then, Judge Johnson was talking about the Mother May I game. Man, temporary administrations are a total Mother May I game. You've got to get, you got to get permission to pay a lot of bills. And so that's a very that's a challenging thing when people are just busy enjoying the fruits of their labor and they don't think about what happens if they pass.
No, that's fair. And I guess the last main question we have is, what are some of the most common pitfalls in the state administration? And with that, I'll ask you all the same question. If you just give us take a few minutes to respond. Judge Jones Johnson, excuse me. What do you wish you had known earlier in your career about handling probate matters? What are some key takeaways you think people should take from this conversation?
It goes hand in hand a lot of times with family law and all the drama. And I hated family law. Oh my gosh. But the good thing is that we can always encourage the family to mesh and get along. Because if they don't, then they won't have much to inherit.
That's fair. Mike, what are your thoughts on this? What did you wish you had known earlier about handling probate matters?
So making sure people know what is going to happen and setting expectations at the very outset of a case on what can happen based on what county we're in, what different impacts a family situation will have. Being able to know that all the way through to tell my clients ahead of time to set those expectations before we got into some complicated probate matters.
Fair. And Chris?
I'd echo what Judge Johnson and Mike were saying. It's a it's a slow process. Even if you get your letters quickly, it can be a very slow process. It's very detail oriented. There's a reason why estate planners joke is that about if you don't like someone, make them your fiduciary. It can be a yeah, it's hard, and and you're held to a high standard. And so I wish that I, I mean, that's kind of I don't know if I'm answering the question, but it is a drawn out process, and there's things that pop up all the time. And kind of echoing what Judge Johnson said, it's not just, an area of law that you got to know family. You got to know corporate law. You got to know a little bit about your intellectual property law, like Judge was saying. You got, in partnership law, you got to, there's, it's an area of law where you never know what kind of random thing is going to come in the door that you have to deal with. Oh, okay. I didn't anticipate that I was going to have to understand how you reduce a child support judgment to child support order to judgment so that the heirs can collect on that. But yeah, that's something I'm going to have to go and figure out. It's I love this area of law. I think when I first got into it, I was a little bit like, oh man, that's yeah. I didn't understand just how diverse and challenging it is. And it's a great place to practice. You can, if you're good at administrate, you like to, check the box and do things that are administrative in nature. You can scratch that itch. If you like litigation, you can scratch that itch. It's growing. I mean, they talk about it all the time about how this generation of the baby boomer generation is graying and getting old, and we're facing one of the largest wealth transfers in history. And there's just so much to be done, and it's a very, I think, interesting area of law that is very challenging and is always something new. Yeah, you see things over and over again. Some family dynamics are recurring, but it's each case has its unique flavor, and so I wish I'd known that early on, and I might have gotten into probate sooner.
That's awesome. So first, thank you so much to all of our distinguished panelists for sharing their expertise today. We hope that the people who joined us are walking away with practical guidance and takeaways that you can apply when you get the faithful phone call from your client. Please remember to take the CLE code from the chat box, and we appreciate you attending. Thank you so much.
Thank you for having us.
Thank you.
Thank you.
Thank you.